President, State of Ohio versus Tiana Sapnakar in case 25 CR 1698. We're here today for purposes of sentencing, and the defendant is in court, represented by counsel William Watson. When we were last here, the defendant waived indictment and pled guilty to count 1 in the information being possession of cocaine, a felony of the 5th degree with an attached forfeiture specification. The court ordered a pre-sentence report and drug and alcohol evaluation. Those reports have been completed, and the state's prepared to proceed with sentencing.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Ms. Sapnakar, unfortunately, is no stranger to courts. She's been in and out, mainly due to drug problems and some petty theft issues. Now, for this particular case, she was still on probation in Willoughby. She had completed most of it. From her perspective, and obviously she was wrong, but she thought she was done. But she wasn't, and there was a warrant out for her. So she was stopped as a passenger in the car. There was drugs found, cocaine found. Of course, they found out about her warrant, and I believe she picked up another theft charge out of that. So there were 2 misdemeanors out of Willoughby, and then this case here, Your Honor. The Willoughby cases have been resolved. Wanted to consider treatment, but she's had a problem for years, and I always lean toward treatment over prison, but Ms. Sapnakar questions her success if she were to go that route. And I'm going to at least give her credit for being honest with herself and everybody else, although I'm disappointed in that choice. But Your Honor, she has struggled with the drug problem, was essentially homeless. She was living with a gentleman who was abusive toward her. She was trying to leave him when all this was going down. She has 2, I believe, teenage daughters. A reasonable sentence, on the lower end. Your Honor, she does have apparently a prison number, and I just confirmed with her. And as you can see by the look on her face, she was unaware of that. She's
unaware of everything. Apparently, she doesn't know she's on probation. She doesn't know she's
never been
in
in
prison.
But she did say that with that last sentence, she actually never did go to prison. I did confirm with her. She did finish out her time here. So in her mind, she's never been to prison before. I understand, from the court's perspective, obviously there's a difference there. But I'm going to respect
the reason she didn't go to prison was because Judge Collins and then Judge Condon apparently gave her 1, 2, 3, 4, 5, 6 chances on probation before she was finally terminated. So she built up all that credit.
Correct, Your Honor. So, Your Honor, again, I'm going to respectfully ask the court for that. Again, she wants to get her life back in order. She's going to get out, regardless of the sentence this court gives, get out someday, and I hope she's sincere with that, and I hope she's able to do that, Your Honor. Thank you.
Thank you. Ms. Sapnakar, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I just want to apologize, Your Honor. With the probation whole thing, I honest to God, I did not know that I wasn't off. I completed everything. I did my mental health assessment. I did one-on-one counseling. I talked to my probation officer a month before I was to be off, and he didn't tell me to come in. He said everything was fine. Then my phone got shut off, and I was homeless, living in a park for I don't know how long, and I just assumed that I was off. I've been with this guy who's been abusive to me for years, and this last time he was choking me out, and the last time he choked me out so badly that I was unconscious and I had to be revived. So I had this girl pick me up, and she picked me up. She had drugs in the car. I didn't know about the drugs, but I got charged with a straw, and it was mine. The straw was mine. I'm not going to deny that. But then I was told if I didn't plead to it, I was going to be indicted with more charges, which I didn't know what they were. I only assumed that I was going to get charged with all the drugs in the car. So I pleaded out to the straw. Yes, I am a drug addict, and I am grateful to have been put in jail because I've been wanting nothing more to get clean. And I am clean now, and I want to stay clean. I just want to get my kids. They're 20 years old. One of them lives with my mother, and she hates it there. And I just want to finish my time so I can get my daughter out of there, get in some type of housing, and get my life back now that I'm away from this guy. I've had no contact with him. I haven't contacted him at all since I've been in jail. So I've been away from him, and that's all that I wanted. And I'm just tired. I'm exhausted. I don't want to do drugs anymore. Honest to God, I don't. I know there's people out there who don't do drugs, and they have a happy life, and that's all that I want. I'm just asking that you please be lenient with the sentence. I've been in jail for 90 days. I know that it's not in this case. I just said that. I know that it's not in this case. But I'm just asking that you please be lenient with the sentence and let me get back to my life and so I can start over. And that's all that I want. And I'm sorry.
Thank you. Mr. Leslie for the State of Ohio.
Thank you, Your Honor. The state is recommending prison. The defendant has a criminal history including 17 misdemeanors. In 2017, she was convicted of attempted tampering with evidence, a felony of the 4th degree in possession of cocaine, a felony of the 5th degree. She was placed on probation. In that case, she violated the terms of her probation numerous times before ultimately being sent to prison. And at the time of this offense, she was on probation in Willoughby Municipal Court and had an active warrant out for her arrest. She has already been through treatment on multiple occasions, including the jail treatment program, as well as NeoCap, and despite those prior efforts at treatment, she has reoffended. So the state is recommending prison. Because she is currently serving a sentence out of Willoughby Muni, she only has 3 days credit. Thank you.
Thank you. Ms. Sabnikar, you do know that we have the ability to see your text messages, right?
Yeah.
Yeah. Joe Evans is all up and down these text messages.
After I found out.
You sat there a moment ago and said you haven't had any contact with him. You cut him off.
I did cut him off.
Okay.
If you read the messages, he hacked my bank account and I was trying to get back my bank account information because he was stealing all of my money. And I have disconnected him and I haven't called him.
There's tons of messages here that you sent. Are you sending him?
Not recently.
Well, what's recent?
I don't know. Like I said, the last one you can read, it's talking about him getting in my having stolen all of my money. I was trying to be nice so I could he had access to the only money that I had, the only way I could get any money on my books. I have nobody doing anything. And the only way was he had all of my information. So I had to play nice.
Well, I'm saying you sat here and said you haven't had any contact with him. You cut him off.
I did.
And that's not true.
But I did recently. Right. If you look at the last ones, it's telling him, I'm done. I don't care what you say. Loser, goodbye.
I'm not going to argue. This court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here today. All this is considering the purposes and principles of felony sentencing set forth in 29:29:11 of the revised code.
He hacked my bank account, Your Honor. He had all my money. What was I supposed to do?
I don't know.
I mean, he stole everything that I had. I have had no money on my books the whole time almost because I have no one else. So
you're talking about how much you love him here in this one message I'm looking at right here.
And when was the date on it?
February 6th.
Okay, and after that, I told him, after my daughter came up and got my property, I'm just trying to explain, you're taking it all out of context. After my daughter came up and got my property and changed my information, I told him to go get fucked and goodbye.
And considering the factors in 29:29:12, factors indicating the conduct is more or less serious. Nothing stands out factually indicating it's more or less serious. As for recidivism factors, almost all of these factors are present. The defendant was on probation at the time she committed this offense. She's got a lengthy criminal history. She has failed before in the past to comply with previously imposed sanctions ordered by court. She's been on probation before in the past. She's violated multiple times. The last time, again, that when she ultimately went to prison, she had 6 opportunities before she was sent to prison. And that's just in that one case. There's multiple violations in a lot of cases. She's previously been sentenced to prison before. There's a drug abuse problem that relates to the offense, and she doesn't want treatment. She prefer to go to prison. In this case, there's no genuine remorse. She actually denies committing the offense, claimed that none of the drugs were hers.
I said the straw was mine, Your Honor.
No factors indicate recidivism is less likely. 29:29:13B1, the court again finds the defendant was on probation at the time she committed the offense, is previously sentenced to a prison term. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 10 months. She has credit for 3 days. Need to advise you upon your release from prison, you can be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, The parole authority could send you back to prison as punishment for violating the rules for another 5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I'm going to order the forfeiture of the contraband and instrumentalities. That covers everything. Mr. Lushy, is there anything I've omitted that needs to be addressed?
No, Your Honor. Thank you.
Mr. Watson.
Nothing further, Your Honor.